Welcome everyone to the Committee of Judiciary and Hawaiian Affairs. Today is Friday, February 9th, 2024, 2 p.m. here in Conference Room 325, and we're also doing this hearing by video conference. We're here for the purposes of hearing numerous measures, and I would urge those who are testifying to please try to keep your testimony to 2 minutes. I'll ask you to summarize at that point. And if you're testifying via Zoom, please keep yourself muted and your video off until you're asked to testify, and then mute yourself and turn your video off after your testimony is complete. If you have any technical issues, those on Zoom can use the chat function to check in with the technical staff. If you're disconnected, don't panic, just rejoin as soon as you can and we'll try to get you in line to testify. If the power goes off in the building here and we have to reschedule the hearing or schedule a meeting for decision making, we will post notice as appropriate. If you're testifying by Zoom, please don't use any trademarked or copyrighted images because it kicks us off of YouTube, and that's a problem. And please conduct yourself with aloha and refrain from profanity or uncivil behavior. It's okay to disagree, but let's not be disagreeable. We're all here to do the people's work for the state of Hawaii. Let's go ahead and get started. First up, we have House Bill 1918, HD1, relating to historic preservation. This extends the sunset date for the historic preservation tax credit to December 31st, 2030, and adjusts the cap on the total tax credits for future taxable years. First up, we have the Department of Taxation. Welcome. Please introduce yourself. The floor is yours. Please.
Good afternoon, Chair, Vice Chair, members of the committee. Teresa Zetwick on behalf of the Department of Taxation. We stand on our written testimony offering comments, and I'm available for questions.
As usual in this committee, I always ask for the highlights of your testimony and your comments.
Absolutely.
Because everybody wants to know.
Absolutely. The department is able to administer the tax as long as some dollar amounts are inserted and an appropriate effective date.
Okay.
Thank you.
Thank you very much. Next, we have testimony from Department of Land and Natural Resources. Dr. Downer, pleasure to see you, sir. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. I'm Alan Downer. I'm the administrator of the State Historic Preservation Division. The department stands on its testimony in support of this measure. This would extend the sunset date for excuse me, for the tax credit, which will expire if nothing changes at the end of next year. We have found the tax credit to be very helpful in terms of preserving particularly older homes, allows people to stay in their homes who might otherwise, frankly, have been unable to afford to do the rehabilitation. We originally proposed in the draft measure that it increase by $500,000 a year. The current cap is $1 million, so that in 2030, which would be the new end date, it would be $4 million. I'd be happy to answer any questions.
Thank you very much. Next, we have testimony from the Tax Foundation of Hawaii.
Good afternoon, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We do question the public benefit of this credit. We also note that we aren't the only one to ask this question. We do cite in our testimony the comments of the City and County of Honolulu, a Real Property Tax Advisory Commission, which raised the same question. Thank you for letting me testify, and I'll be happy to answer any questions.
Sure. Thanks for testifying, Mr. Yamachika. Next, we have testimony and support from the Historic Hawaii Foundation, testimony and support from Scott Kidd and Linda Legrand. Anyone else wishing to testify on House Bill 1918, HD1? If not, questions, members? Seeing none, we'll move on. Thank you. House Bill 1902, HD1. HD1 refers to House Draft 1. It's already been modified in one committee, so that's why it's an HD1. So HB 1902 HD1 relating to emergency management. This measure clarifies that the governor's and mayor's emergency management powers shall be consistent with the state constitution, clarifies the scope of the comprehensive emergency management plan, clarifies the powers of the governor and the mayors to extend or terminate a state of emergency, and shortens the duration of price control periods from 96 hours to 72 hours. First up, we have testimony from Hawaii Emergency Management Agency. Not here. Next, we have testimony and support from Hawaii Realtors. Welcome, Ms. Garcia. Floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Lindsay Garcia from Hawaii Realtors. We stand in strong support of this measure. We believe that it is good for transparency for both consumers as well as businesses. And we humbly ask for your support and please passing it out as is. Thank you.
Thank you. Next, we have testimony and support from the Retail Merchants of Hawaii. Please proceed, Ms. Yamaki.
Hello and good afternoon. I'm Kina Yamaki with the Retail Merchants of Hawaii, and we are in strong support of this measure. I wanted to point out that during disasters, a lot of times people think that we gouge prices, and that's not really the issue. And I know that's why there's a price freeze on a lot of things. What it happens is a lot of times the smaller, cheaper products go out faster, and people buy the more expensive designer brands, quote unquote, in larger sizes, so that is more expensive. And with social media, we are having to keep our feet to the fire and making sure that we are on the up and up, and we do not do that. This bill will also help retailers know what is allowable and what is not when price freezes are happening as well. Mahalo.
Thank you very much. We've received written comments from Grassroot Institute of Hawaii, written comments from Hawaii Restaurant Association, but I see Mr. Victor Lim here. What a treat. Thank you, sir. Konghi Pachoy.
Hi, Konghi Pachoy, everybody. Everybody was surprised that I'm here in person, but I just want to come and wish you a good Year of the Dragon. And the Restaurant Association strongly supports this bill, and because as you can see from the pandemic to the Maui fires, I mean, there's more emergency declarations that last a lifetime for us, so a clarification is definitely good. Thank you very much.
Thank you, sir. Pleasure to see you. Next, we have testimony and support from the Hawaii Food Industry Association. Lauren Zerbil. Oh. Next, we have testimony and support from the General Contractors Association of Hawaii and from Scott Kidd. Anyone else wishing to testify on House Bill 1902? If not, questions, members? Seeing none, we'll move on. Thank you. House Bill 2611, HD1, relating to administrative fees. This measure statutorily establishes a Department of Land and Natural Resources transaction fee for each recording in the Bureau of Conveyances and Land Court. It authorizes the Board of Land and Natural Resources to adopt, amend, or repeal administrative fees, including transaction fees, for recordings in the Bureau of Conveyances and Land Court separate from the administrative rulemaking process. It amends the authorized uses of monies in the Bureau of Conveyances Special Fund and repeals language that required Bureau of Conveyances microfilm fees to be established by rules. First up, we have testimony from the Department of Land and Natural Resources. Les Kobata. Welcome, sir. Pleasure to see you. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. Thank you for having me. Our bill, the DLNR strongly supports this bill. It's actually meant to fix a technical flaw that was in Act 120, Session 2009, where the transaction fee was charged only on regular system documents. So what we're trying to do is make sure that we can be fair to the public and also to be able to support our operation by creating, I shouldn't say create, but by reinstating the $5 transaction fee to land court transactions as well. We've also, in our testimony, added some language to correct or at least to fix something that we had in the bill previously that was not meant to be, which was all administrative fees being covered under BLNR. We understand that HRS 91 is meant to cover administrative fees in general, and we're just asking for the transaction fees only to be covered under the BLNR purview. I'm available for any other questions if you have them. Thank you.
Great. Thanks very much, sir. Anyone else wishing to testify on House Bill 2611, HD1? If not, questions, members? Seeing none, we'll move on. Thank you. House Bill 2473 HD1 relating to conservation mitigation programs. This measure authorizes the Department of Land and Natural Resources to operate and approve conservation bank and conservation in lieu fee mitigation programs. First up, we have testimony from the Department of Land and Natural Resources. Welcome.
Hi, good afternoon, Chair, Vice Chair, and members of the committee. My name is Catherine Stanaway. I work at the Department of Land and Natural Resources, Division of Forestry and Wildlife. And we really want to emphasize that this is a no-cost bill and would bring another revenue source to DLNR. We made several amendments to the measure to clarify what had been brought up in testimony from the last committee. And do you want me to go over those amendments?
Highlights of it.
Okay. First, we recommend striking all references to conservation bank and conservation in lieu fee mitigation programs for prospective damages. We also recommend past damage mitigation requirements be applied to any indigenous species. We want to clarify conditions for establishing and operating conservation banks that require sponsors to have funding assurances in the form of endowments. And that it would also apply to, that applies to conservation banks and conservation in lieu fee programs. And then for conservation in lieu fee programs, we wanted to ensure that they were established and operated under a conservation in lieu fee instrument with a compensation planning framework. And then also, and that those sponsors are required to provide a schedule for implementing mitigation activities. And then we wanted to ensure, this was from a question and testimony from last committee, wanted to ensure that sponsors are responsible for performing all mitigation activities and that they assume responsibility for all mitigation obligations from the entity who purchases or transfers credits from that sponsor. And that the Endangered Species Recovery Committee will review and recommend conservation bank programs annually.
Great, thank you very much. And then we have testimony from Earth Justice. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. David Henkin from Earth Justice. In our written testimony, we tried to emphasize the fact that when you're dealing with these types of issues involving Hawaii's endangered and threatened species, it gets very complex very quickly. And nothing's a better illustration of that than the DLNR's testimony where, again, this is an administration bill. So they drafted the original bill. And then they proposed amendments to the last committee, and now they're proposing pages and pages of amendments that no one's had a chance to review or look at to this committee. We did talk with DLNR before session. They raised this concept of conservation banking. It's not inherently, a bad idea. What is a bad idea, in our view, however, is rushing forward with passing legislation that hasn't been fully thought through. Which is why we urge the committee to establish a working group to come up with a recommendation for next session, rather than try and basically build the airplane while you're flying it, particularly when our endangered and threatened species are in the balance. This just hasn't been thought through. Everything that they just testified about has all sorts of policy issues, like why you would put on the conservation bank the need to do adaptive mitigation rather than on the person who's getting the license for incidental take. And on and on and on. So we just, we feel that the administration didn't think this through before they submitted their initial bill, and they haven't thought through all their amendments, and it would be good to take a pause and just have an expert working group make recommendations for next session. We urge you to do that. Thank you.
Thank you very much. Anyone else wishing to testify on HB 2473 HD1? If not, questions, members? Ms. Stanaway, thank you for being here. I'm sorry you got a cold. I hope you get over it soon.
Thank you.
Are there opportunities for stakeholders to be involved in some of the work that you're doing to develop this bill? And, Mr. Henkin was saying that, this is a surprise, so have you been in conversation with stakeholders such as Earth Justice or others as you were developing this bill?
We have, actually, a version of this type of bill has been before the legislature for a number of years. This version has been more well-developed than the other versions. The other versions weren't written by the department, and this one is.
Yeah, I proposed some of these measures in the past, so I understand that.
Yeah, thank you. We greatly appreciate that support. We started conversations, initiating conversations in August with environmental groups. We reached out to Earth Justice, Sierra Club, American Bird Conservancy. We reached out. This type of bill would impact Habitat Conservation Plan incidental take license holders, and we reached out to them to get their feedback. We reached out to actually a group that operates conservation banks on the mainland called Magnolia. We reached out to California, who runs a conservation bank program, and they've had a model for other states as well. So we used a lot of materials from them. The federal government has operated conservation banks and conservation in the fee programs for both wetland and terrestrial sites, and we looked at materials from those laws. So we've done extensive research on this. A lot of the additions were things we were going to add in administrative rules, but because they came up in testimony, we wanted to add it to the statute.
Okay, great. Thank you very much. Other questions, members? If not, thank you very much. And I would just like to notify everybody, including the previous testifier, that this committee has made it a practice of posting the testimony as soon as it's available and compiled by our committee staff, and that's usually the day before, so people have a chance to read the testimony. It's not required under our rules, but I try to do that to make sure everyone has a chance to read everyone else's testimony, so it's not a surprise. So I would urge you, if you're interested, to track the work that we do in this committee. Check the availability of testimony the day before the hearing, so you have a chance to read everything, so it's not a surprise. So I really try to make sure that the public is engaged and has all the information. So actually, at the same time that the rest of the committee members get it, so does the public. So that's my approach. Okay, no further questions on HB 2473 HD1. Let's move on to the next measure, HB 2174 HD1, relating to search and rescue. This measure repeals the existing conditions under which government entities may seek reimbursement for search or rescue expenses, and instead requires a government entity of the state to impose and collect a fee for search or rescue expenses for persons who require rescue after leaving a hiking trail to enter an area closed to the public or hiking on a trail closed to the public with a sign giving notice of the closure. This bill also requires a report or documentation of the rescue to be submitted to the Department of the Attorney General. First up, we have testimony and support from the Department of Law Enforcement. Testimony and support from Keone Shizuma. Please proceed, Keone Shizuma.
Hey, aloha, aloha Chair, aloha Vice Chair, and committee members. Mahalo for the opportunity to testify. Keone Shizuma, testifying as an individual in support of this bill. I wanted to say I come from a background with ample experience hiking around on our state-maintained trails, as I used to work for the Department of Forestry, maintaining or targeting and tracking invasive species within our forest reserves. And with all that experience hiking around, I have to say that we definitely have an ample amount of trails that are maintained well for any experience that people need. And there's no real reason for people to be trespassing or leaving the trail or going into closed areas. So I am in strong support of this bill. I also feel that, if they are gonna transverse into closed areas, then they do deserve to be fined as well. I do believe that there probably will be some extra maintenance on the trails needed so that it is marked well, but after that is maintained or implemented, it definitely would be it would make sense for this, for the state to require the reimbursement of the search and rescue operation. So thanks for the opportunity to testify.
Thank you very much, sir. Next, we have testimony with comments from Todd Yukutake and testimony in support from Scott Kidd. Is there anyone else wishing to testify on HB 2174 HD1? If not, questions, members? Nope. Nope. No questions. We'll move on. Thanks very much. Next measure, House Bill 2420, relating to the Department of Hawaiian Homelands. This measure gives practical effect to the intent of the legislature that funds appropriated in Act 279, Session Laws of Hawaii 2022, be available for expenditure until June 30th, 2025. First up, we have testimony and support from the Department of Hawaiian Homelands. Deputy Director, pleasure to see you. Aloha. Please proceed.
Aloha, Chair Tarnas. Aloha, Chair Tarnas, Vice Chair Takayama, members of the committee, Katie Ducat on behalf of the HHL, and we are in strong support of this bill, which would address the technical flaw in Act 279 with regard to when funds would lapse. There's been a lot of discussion about this. This is a bill that we believe would achieve the intent of the legislature, given the constitutional limitations related to the biennial budget. So that we are in strong support. Thank you.
Thank you very much. Next, we have testimony and support from the Department of Budget and Finance. Is there someone on Zoom? Nope. Next, we have testimony with comments from Tom Yamachika, Tax Foundation of Hawaii. Mr. Yamachika, please proceed.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We do recognize this is a technical fix, and we'd be happy to answer any questions. Thank you.
Thank you. And we have testimony and support from Leimomi Khan. Is there anyone else wishing to testify on HB 2420? If not, questions, members? Representative Ganadin, please proceed.
I guess just out of curiosity, I mean, 2022 was a banner year for the department. It was kind of touted in the media, and we had a whole bunch of signing ceremonies about the $600 million being directed towards the department. About how much of that has been encumbered so far?
I apologize. I do not have that number off the top of my head. I should. But I do believe we are on target to actually encumber it by this fiscal year. That's actually the goal of Chair Watson, and I know Chair Tarnas has been sitting on the HR 10 committee. So that is the goal. This measure is in case we do not meet that goal. So in other words, what I'm saying is I do believe that currently we are right at or right under 600 million encumbered. So there might only be about 100 or so million left. I hope I'm not misspeaking, but that's my remembrance of the reports that have been given thus far. In fact, what our chair is trying to do is get $600 million more for a phase two to continue the good work that was started with the very generous appropriation of the $600 million. So
Well, I'm only asking because I was kind of big in the news, the issues that other departments have in encumbering funds. For example, the Department of Education has been brought before the Senate a few times actually for these kinds of issues. So if you're telling us you're on track, that's really good news.
yes, we are.
Thank you.
Thank you.
Thank you very much. Any other questions, members? If not, let's move on. House Bill 1932 HD1 relating to the Department of Transportation. This measure authorizes the Department of Transportation to acquire any real, personal, or mixed property for immediate or future use, own, hold, improve, rehabilitate, sell, assign, exchange, transfer, convey, lease, or dispose of any real, personal, or mixed property acquired, and acquire by condemnation real property for immediate or future use. The measure amends the definition of public lands to exclude lands to which the Department of Transportation holds title, and authorizes the Department of Transportation to directly acquire any real property for its purposes. On this measure, we have testimony from the Department of Transportation. Welcome. The floor is yours.
Thank you, Chair Tarnas, Vice Chair Takayama, members of the committee. Tammy Lee, Deputy Director for the Department of Transportation. For this measure, the DOT has firsthand knowledge and expertise in airport, harbor, and highway operations, as well as land management. We support the legislative intent to streamline the land disposition process. We support the effective date of January 1st, 2025, to allow time for rulemaking in accordance with the administrative procedure that are outlined in HRS 91. And I'm here for any questions. Thank you.
Thank you very much. Next, we have testimony from Sabrina Taylor, Signature Aviation. Please proceed.
Aloha and good afternoon, Chair, Vice Chair, and members of the committee. Thank you for the opportunity to testify. I'm Sabrina Taylor, Vice President, Airport Relations and Strategic Programs representing Signature Aviation. I stand on my written testimony, but also wanted to provide a few brief comments today. I just wanted to highlight that Signature is the world's largest aviation terminal operator, and we operate at 6 of the state of Hawaii's airports. We provide fuel services to the airlines in Hawaii, and we also handle private jet operations, among other services, in over 225 locations worldwide. We're currently working with the DOT on a master plan, and we're ready to make an investment in the neighborhood of $40 million in our facilities at our Hawaii airports. We are in strong support of this bill, which would streamline the process for reviewing and approving lease of land that the DOT holds title to at its Hawaii airports. And we believe the benefits of this bill not only improves the administrative efficiency, but also opens the door for accelerated capital investments by airport tenants. And Signature stands ready to support what's needed by the state and the DOT if the bill were to pass. Mahalo, and thank you very much for your consideration.
Thank you very much. Next, we have testimony in support or in opposition from Regina Gregory. Is there anyone else wishing to testify on HB 1932 HD1? If not, questions, members? Seeing none, we'll move on. Thank you. House Bill 2673 HD1 relating to roads. This permits the counties to use county surcharge revenues for maintenance of private roadways that are open to the public. It requires the counties to use fuel taxes for reconstruction, improvement, repair, and maintenance of private roads that are open to the public. First up, we have testimony from the Attorney General. In person, welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chairs, members of the committee. Winston Wong, Deputy Attorney General. We have a few comments on this bill, the first of which is in regard to an existing provision of the county surcharge that deals with a prohibition on the use of these funds to public roads that were in existence prior to 2005. The passage of this bill, as written right now, could lead to an uncomfortable result where the state is prohibited from using certain funds on public roads that were in existence, but they're allowed to use them on private roads. The second comment that we have is addresses basically the requirement in the Hawaii State Constitution that public funds be allocated or appropriated for public purposes. Currently, the purpose section of this bill is a little bit spare. It could be bolstered, in effect, by really addressing how the public good and the public purpose could be achieved by using public funds to maintain these private roads. I will be available for questioning afterwards.
Thank you. I appreciate your testimony with suggested improvements. Next, we have testimony from Tax Foundation of Hawaii, Tom Yamachika. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. Will stand on written testimony be available for questions.
Thank you. And then we have testimony in opposition from Scott Kidd. Anyone else wishing to testify on HB 2673 HD1? If not, questions, members. Representative Ganadin, please proceed.
Mr. Wong with the Office of the Attorney General. Something that representatives like myself, I represent part of urban Honolulu, so like Kalihi, Lower Kalihi, Pearl Harbor, Hickam, a lot of private roads that have now accrued to neighborhoods where the landowners are long dead or long gone. I shared that in common with representatives from rural areas, like the introducer of this bill. We're looking for solutions for how to mandate that the county improve these private roads, quote-unquote private roads that have now become quite public roads, and for public safety. I'm trying to read through your testimony. Do you think that the prospective HD2 and changing the preamble, as you suggest, to better articulate what the objective is to serve a public purpose in lieu of private interest, is that enough to allow this bill to survive onto the next committee and maybe the rest of the legislative session?
I believe so. Yes, Senator. Rep. I do believe so. The counties are empowered under current county ordinances to maintain private roads, so there is precedent and there is authority with the counties to actually invest their resources. But as to the certain revenues achieved from the county surcharge tax, this would just specifically say that they do have that authorization. Specifically mentioning that in the purpose section would bolster this bill enough to survive subsequent committee referrals.
Right. I mean, part of it is they just don't say it. So when we go to our neighborhoods and we have to talk about simple things like potholes or flooding roads, we say it's the county's issue, and then the county says, we can't do anything because you don't have enough money. Maybe you should take it up with the state. Residents get really tired of us passing the buck.
Certainly, Rep.
Is there any way that we can mandate that the county get involved with private roads or alter them to become public roads? Like, is that too far of a stretch for this bill, or is that something that we need to take up in an entirely new piece of legislation?
To my knowledge, this bill deals specifically with the county surcharges on state tax, so it's mostly with the appropriations of the revenues received from that. In order for the states to take over these county roads or to take over the maintenance, I think that maybe an eminent domain proceeding would probably be best suited for that in order to actually have jurisdiction over those roads, because currently I think the roads would be the maintenance and the jurisdiction of the counties. But if the state were to instigate those proceedings pursuant to a separate bill, that would be more appropriate. But under this current bill, because it does deal mostly with funding and how that funding is allocated and used, I think this bill would be probably not as well intentioned to that end game. But if the intention is to allow the counties to use these funds to go forward, and if you believe that they can really affect the purposes that you already have in mind, then this certainly could accomplish that if the purpose is indeed bolstered.
Okay. Is kind of the process by which the county pursues eminent domain over a private road, is that so cumbersome that they just don't touch it? Because it seems like a perennial issue in the state of Hawaii. We've got so many of these private roads that have become like highly used by communities that we're just kind of running into so many issues about this.
I mean, I can't really speak for Corp Counsel, but just generally, eminent domain proceedings can be largely contested. I think we just have to look at the rail project as an example of that they can be expensive, that the fair market value of land to be condemned is often contested as well. So they can be drawn out procedures if there isn't an agreement from the existing landowner, or in this case, the road owner, to agree on a price to transfer over and what is fair compensation for that land to be taken. So it is a highly contested type of issue going forward, and I don't think it would be any different if the state were to pursue those same type of proceedings as it would be with Corp Counsel. I think the constitutional requirements and protections for private landowners, as well as the requirements upon the governments in affecting those, would be the same.
Okay. If you're happy with the amendments in a prospective HD2 in the survival of this bill, I guess we're happy. So
I will certainly stand on the testimony and the proposed commentary. I think that it'd be sufficient.
Thank you.
Thank you.
Thank you very much. Any other questions? If not, thank you very much. Thank you. Let's proceed to the next measure, HB 2267 HD1, relating to highway safety. This measure establishes the Automated Speed Enforcement Systems Program, authorizes the state or counties to administer the Automated Speed Enforcement Systems Program, requires fines collected beginning January 1st, 2025 for violations on a county highway to be expended for the operation of the Automated Speed Enforcement Systems Program, and creates a new offense of noncompliance with the posted speed limit under the Automated Speed Enforcement System. and appropriates funds. First up, we have testimony with comments from the judiciary. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Michelle Acosta, for Deputy Chief Court Administrator for the First Circuit. I'm here on behalf of the judiciary. We have submitted written testimony with some comments, and in brief, our comments pertain to the implementation date of January 1st, 2025, and requesting that it be considered for a later date in accordance with the scope of this project. The judiciary is responsible for processing the citations once issued, and so we just ask that that be considered in the timeline for the enactment or implementation of this bill. Thank you.
Great, thank you very much. We have testimony and support from the Disability and Communication Access Board, testimony with comments from the Department of Budget and Finance, and testimony and support from the Department of Transportation. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Tammy Lee from the DOT. The DOT stands on our written testimony and support. According to the DOT traffic data, speeding continues to be the most common contributing factor in motor vehicle fatalities. Automated speed enforcement cameras are powerful tools that can reduce motor vehicle crashes and fatalities by augmenting traditional enforcement efforts or enforcing on locations where traffic stops are impractical or unsafe. And I'm here for any questions. Thank you.
Thank you very much. Next, we have testimony and support from the Honolulu Police Department.
Good afternoon, Chair, Vice Chair, members of the committee. Major Stason Tanaka from HPD's Traffic Division. HPD supports the bill as it addresses the enforcement of speeding vehicles. Higher vehicle speeds equate to less reactionary time, as well as higher propensity for property damages and injuries. In addition, speeding is a major contributing factor to many motor vehicle collisions, resulting in critical injuries and fatalities. I'll be here to answer any questions.
Thank you very much. Next, we have testimony in opposition from Alan Akau. Welcome. Please proceed.
And good afternoon, Chair, Vice Chair, members of the committee. Alan Akau, Deputy Public Defender, representing the Office of the Public Defender in our testimony. Ultimately, our testimony is in opposition. As HPD said, while it does aid in providing additional tools in speed enforcement, we'll note because of the time it takes in which these citations would issue, it doesn't really give Honolulu Police Department any discretion. Simply they're reviewing the data that's provided to them. It doesn't give them discretion to make stops. The citations are mailed pursuant to the way in which the bill is outlined. We'll also note that it can draw issues of due process, notably in the prosecution phase of such citations, because no officer can testify directly to any of the circumstances in which the citation was issued. We'll note that also issues with the vendor, as we've seen recently, the ability for the Honolulu Police Department to use PACE to determine whether or not a motor vehicle operator is going in excess of any speed limits have been challenged and thrown out, mostly due to the inability to re-up the contract with their vendor, which was RAD Motorsports. So similarly, we believe that the use of a third-party vendor to control so much of the citations and discretion for charging and later issuing those citations, we believe is an error. So for those reasons, our office does oppose this matter. And I'll be available for comment. Thank you.
Thank you very much. Next, we have testimony with comments from Luke Wasserman, testimony in opposition from Natalie Iwasa, testimony in support from Chad Taniguchi, testimony in support from Cindy Watanabe, testimony in opposition from Scott Kidd, and testimony in opposition from Robert Gould. Is there anyone else wishing to testify in HB 2267 HD1? If not, questions, members. Representative Ganadin, please proceed.
To the Department of Transportation. Handing out automated speeding tickets through an entirely automated process. I can't think of anything that would irritate local drivers more. Do do we have data on the success or lack thereof of the red light photo imaging pilot project that's been going on here on Oahu? Like, how has that been successful?
Yes, it has been successful. Since the pilot, we've issued 18,583 citations. 800 of them were dismissed, and that's because of challenges to who holds title. You know, the seller sells a car, you're supposed to take the title to the county to register as a new owner. So those are, you know, the ones that have been dismissed. I know that there was one that went to court, and I have subject matter Lee Nagano on the call to discuss that.
Hi, good afternoon. Happy Aloha Friday, Chair, Vice Chair, and members of the committee. So we have the red light running pilot program. It's a 2-year pilot program in Honolulu in District 1 at 10 intersections with 17 cameras. And at every location, we've noticed a 40 to 50% decrease in incidents to show that it has been decreasing and changing driver behavior in a positive manner. As required, we've submitted an annual report to the legislature on our results. But we'd be happy to resend it to you if you'd like.
Lee, can you comment on the court case that we spoke about earlier this week?
Yes, so there was one dismissal due to the mailing date being missed, not being on the citation, but it was addressed through the evidence package, and there's been no dismissal since then. Thank you.
But this is a different kind of a program. Where, I'll just share a brief story of it real quick. One time I took a taxi from Seoul, Korea to the airport in Seoul, which is about 40 minutes out. And the taxi driver was speeding. And then every time he would get underneath one of these known cameras, him and the dozens of cars next to him would slow down almost to brake and then speed back up for another 2,000 yards and then stop and then go, and stop and then go. It was nauseating. Are you thinking of putting these kinds of speed catchers on like H1, H2, H3?
So the process that we're going to go through is to do an engineering review. Of course, we're going to put these cameras, after we do the studies on, conduct a baseline of the average number of vehicles that are violating, and then give notice. So I think the short answer is yes, that would be within our jurisdiction. But we have a lot of studies, like the engineering studies that I mentioned about to do before we, even begin with the pilot.
How much is this pilot going to cost?
I think in the appropriation. Go ahead, Lee.
Oh, I'm sorry. It would be to depend on the number of intersections selected and the number of cameras determined. For the red light running program, we have 10 intersections, 17 cameras, and it costs $92,000 a month.
And the total appropriation was that $2.4 million for this pilot, red light running.
2.8 million.
2.8 million.
For the red light running pilot.
Okay. Thank you.
And this is all, special funds, special highway funds that we use for the red light running.
By that you mean they're already allocated from some other fund that is not the general fund? And
Correct. So I think it was in 22, 21, Lee, when we got the red light running appropriation, and it was to allow us the use of the state highway fund with the different revenues that come in, so it wasn't general funds.
Okay, thank you.
Thank you. Vice Chair?
Deputy Director, could you stay up there? I have a couple questions following up on Representative Ganaden. You talked about a study of the average speeds on H1, H2, H3. Driving in from Pearl City this morning, I can tell you that every one of the drivers on H1 between Pearl City and here was in violation of the speed limit. So I'm not sure. Well, going to my question is, would your implementation of speeding violation cameras provide for any kind of leeway in terms of a marginal speed over the speed limit that is not ticketed? For example, if it were up to a police officer I doubt that they would issue a speed ticket for someone going 56 or 57 and a 55. What discretion would you allow for implementation by the cameras?
Lee, can you help me with the answer? My understanding, reading the bill, that there isn't, right? It's all the statutes from what the speed limit statute, violation of the speed limit statute.
Hi,
So
the
there's no leeway.
Department of Transportation has been engaging with the 4 county police departments, the Attorney General's office, as well as the prosecutor's office to determine, if we're lucky enough to have this bill pass, things like a threshold, and would it just start in school zones or construction zones? So we're still in active conversation with them.
Does, Deputy Director, does your institutional memory extend back to the prior use of these speeding cameras about 20 or so years ago?
All of my team tell me about this. At the time, I was living in Washington State, so I have no recollection of it, but I've heard of it.
How
So
did
we
it
have
work then?
Right. So we have safeguards. What I've been told is that was very controversial. It was on the news every night. I was lucky to not have experienced it. But the safeguards that are in the statute are, that the vendor and the contract cost is going to be the cost of the equipment and the cost of the service that this third-party vendor is going to be giving to us. We're not going to allow, as in the past, for the contractor to take a percentage of every citation that's given out. So we had some lessons learned.
But as I recall, part of the public concern about the prior use of these van cameras was the fact that they did issue citations for as little as 5 miles over the posted speed limit. So I still am not sure how you would handle it differently now.
Sorry, Deputy. We all, the rest of us engaged in the group, remember the first implementation, and that the cameras, I believe, were set for 1 mile and over. And none of us seemed to feel that was reasonable. And again, moving forward, we will take that into consideration. And we did reach out to our current vendor, Vera Mobility, for the red light running project, as they do a lot of speed projects across the nation. And their recommendation is no less than 10 miles per hour.
I'm sorry, no less than 10 miles an hour over the posted speed limit?
Correct.
Okay. My final question, if I may, Chair, is a couple of the testifiers talked about it being permissible, possibly, or being safer to go with the flow of traffic, as opposed to what Representative Ganadan mentioned, and drivers in Korea suddenly slowing down just because of the camera. Is there any possibility of measuring by the traffic cameras some kind of, the speeding cameras, some kind of allowance for going with the flow of traffic, even though it may be above the posted speed limit?
Lee, is that something that we're going to be looking at?
We'll have to look into that and get back to you.
Yeah, because that would be a concern personally, that if people are braking on the freeway just to avoid being ticketed, I think that would present more of a safety problem than speeding itself.
Yes, I agree.
Thank you, Chair.
Certainly. Other questions, members? Yes, go ahead, Representative Ganadan.
I don't see here any testimony from the judiciary. As an attorney, I guess I've had the opportunity to. Oh, is the judiciary here? Oh, yeah.
I'm sorry.
To the judiciary for this case.
Comments?
For this. Ms. Acosta. Should we move this bill forward? What does the judiciary expect the impact to be on its district courts?
So my division and the First Circuit is participating, or we do receive the citations for the red light camera that's in effect right now, the pilot. What we do expect that from that experience, because the citations are issued without any kind of the discretion, the citations will come in faster. So as Ms. Gano explained, there are 10 locations and 17 cameras. This translates to additional citations that come into the judiciary. The impact on the judiciary is that we process those citations, we do enter them into the system, so that requires court staff. Depending on what the plan is for this particular project for the DOT, it could add additional citations coming into the courthouses. If there is something, as Vice Chair was talking about, in terms of going with the flow, this may initiate, as you may know, Representative being an attorney, written statements, meaning that people will explain, I did go over 10 miles per hour, but I was going with the flow. And so this would generate additional written statements in terms of explaining to the court why they got the citation, why they shouldn't receive the citation. So there is an impact to the court in terms of the volume of citations that we may get, or the volume of written statements that the courts may
Thank you.
receive.
I'm sorry. I can't help but be interested in following up. If someone were to write in and say that I was going with the flow, how would he or she prove that, and how would you disprove that?
So it would require a court hearing, and we would rely on on the driver or whoever. So that would generate hearings to determine what kind of evidence.
What would refute the driver's version?
I don't know what this project will look like, so I'm not able to answer.
Thank you.
Representative Gannon.
So, I mean, can you cross-examine a camera? I mean, because can we really effectuate due process here?
I wouldn't be able to answer that. I'm not a sitting judge, and so I wouldn't be, able to. I don't know if the public defenders would be able to answer that question, but I would not be able to answer that question.
All right, thank you.
Thank you.
Thanks. Any other questions? I have one question. I guess it would be for the Department of Transportation. How do you deal with what seems to be a prevalent issue that I see is tinted license covers?
The new camera technology, I'm sorry, Deputy.
No, please leave.
Okay. The new camera systems are a lot more sophisticated, and the tinted covers don't work the majority of the times. And also, it is illegal to cover your license plate. So we've gotten that word out there as well.
I understand it's illegal, but I don't see it enforced very much. At least in my rural district, it happens all the time. So you said you got the word out. Was it you got the word out to the police departments to start enforcing it?
Yes, but as well as, in our early media coverage, when we were discussing the launch of the pilot, we reminded the public that it is illegal to cover your license plates, and the technology, with the current technology, the covered license plate protectors don't work.
Got it. Okay. Thank you. Other questions? This has obviously got a lot of interest. So thank you very much. Appreciate your whole team and everyone for testifying.
Thank you. Good afternoon.
Okay, let's move on to the next measure. House Bill 1934 HD1 relating to driving while intoxicated. This establishes an intoxicated driving reduction working group to make recommendations for amendments to existing laws to reduce incidents of intoxicated driving. First up, we have testimony from the Department of Law Enforcement and testimony from the Department of Transportation.
Thank you, Chair, Vice Chair. The Department of Transportation stands on its written testimony supporting the intent. Right now, we're making an update to the Strategic Highway Safety Plan, and the stakeholders that are involved in the update and the original Strategic Highway Safety Plan are members of Mothers Against Drunk Driving, first responders, police departments. This is a really big collaborative effort that we take months to update. And so we feel that the strategic highway safety plan is the vehicle and the venue to go through all of these types of policy changes for intoxicated driving reduction. And I'm here for any questions.
So you'd rather do that instead of the?
Yes, yes.
Okay, thank you.
Thank you.
Next, we have testimony from Mothers Against Drunk Driving Hawaii. And testimony from Maui Brewing Company with comments, testimony and support from, what is it, American Automobile Association of Hawaii, testimony with comments from Eric Abe, and testimony in opposition from Scott Kidd. Is there anyone else wishing to testify on HB 1934 HD1? If not, questions, members? Representative Ganadin.
To the Department of Transportation, sorry for making you stand up again. I guess since I've been driving, I've seen, and I don't want to admit to drinking, definitely not at the same time. I've seen less incidences, I guess, amongst people that I know of even getting near violating the law because of the use of like taxi services like Uber or DriveShare or Lyft or these kinds of things. Have we seen less incidences of OUIs in the last few years? Or what is the trend?
What's an OUI?
Operating under the influence. So it's the legal term of a DUI.
Got it, thank you.
Thank you, Representative. I have subject matter expert Karen Kahikina, or Carrie, to help out with any statistics.
Hi, Chair, Vice Chair, members of the committee.
Could you move your microphone right in front of your face? Yeah, thank you. Go ahead.
Okay?
Yes.
You can hear me? Okay, very good. I just wanted to state, that's a great question. We did point out in our testimony, since the inception of the Strategic Highway Safety Plan, we've been working on matters particularly around impaired driving. And you're right, we have seen a decrease. And our recent behavioral survey said that actually there's been an increase in the use of rideshare over the past year, 2022 to 2023. So yes, you are seeing a good positive trend, and we hope to continue.
Thanks, Carrie.
I read in your testimony, let's see, in 2006, there was 161 fatalities.
Correct.
And then dropped down to 104 and just 37 last year. Is that correct?
Correct.
Sounds like an excellent trend.
That's the alcohol-related fatalities. Speeding is about 50%.
Differentiated. Okay, thank you.
Thank you. Other questions, members? Just a question. The Strategic Highway Safety Plan revision is looking at all different factors that contribute to impaired driving. Is that correct?
Correct.
Not just drinking. Because it sounds like, I mean, from the data that I remember, is that distracted driving, speeding, and other, those are a higher percentage of the reasons why you're distracted. Is that correct?
Yeah, we have several emphasis areas, like you mentioned. We have a pedestrian and bike safety emphasis area, impaired driving, distracted driving, speeding. So all of those areas take into as a sum the Strategic Highway Safety Plan. So impaired driving is one of them, but we will look at the cross-sectional factors. We know that there's a trifecta between speed, alcohol impairment, and not wearing a seatbelt, but those things are definitely considered.
Okay. Are you looking at other things that might impair driving, other substances that might contribute to impaired driving, and what would those be?
Yes, not just alcohol impairment, but also the leading other polysubstances, which may include things like cannabis, opioids, stimulants, hallucinogens. Those are things that we definitely take into consideration.
And in isolation, those individual ones are you often find them together.
They're more likely to be in combination with alcohol.
Yeah. Yeah, it's tough to disaggregate that, isn't it? Yeah.
Yeah.
'Cause I've been
Yes.
trying to find data on what's the impact of cannabis use on impaired driving, but it's hard to find data that's just specific to that, rather than in combination with alcohol. Is that, you find the same thing in the data?
It's predominantly alcohol, then polysubstance, and sometimes it interchanges. But like you said, it's usually in combination. It just depends on the toxicology report. Sometimes it is isolated, but it's not the predominant as one. Like you're saying, the drug impairment, it's not just one. It's
Yeah.
usually many.
Yeah. Okay, well, should this committee decide to move forward with this measure, I would urge you to, use the strategic highway safety plan work that you're currently doing to, drill down into this area, because clearly it's a public interest and the legislature is interested in this. I really don't know if there's an appetite to move forward with this particular working group as proposed here. We might choose to move it out of this committee, but I don't know if it'll make it out of the legislature as a whole. So yeah, please do continue with the work you're doing. I think it's very helpful.
Thank you. We will.
Appreciate it.
Thank
Any
you.
other questions, members? If not, let's move on. House Bill 2339 relating to 911 services. This measure deletes the term enhanced in reference to 911 services to allow funding of all 911 technologies. It also allows the 911 board to employ staff in addition to the executive director, exempt from chapters 76 and 89 Hawaii revised statutes. First up, we have testimony from State of Hawaii Enhanced 911 Board. Welcome, Mr. Murakami.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Royce Murakami, Executive Director of the State of Hawaii Enhanced 911 Board. I stand on my written testimony in support of HB 2339. Just a brief overview of the bill. It is a housekeeping bill, just to remove the term enhanced. The term enhanced is tied to a specific technology that was introduced several years ago. So the removal of this term just ensures that the board will be able to properly fund all of public safety answering points. And thank you, and I am open to any questions.
If you could just explain, enhanced was the term that was used years ago to describe the certain advanced 911 technology at that time,
Yes.
but now you've got even more advanced, which is not called enhanced. Is that the problem?
Yeah, so basically in the beginning, when introductions of cell phones, we were called wireless. And then from that, we went to enhanced with text to 911 and voice over internet protocol and stuff like that. Now we're moving into next generation 911. So technology just keeps advancing. So the removal of this term will just ensure that, any future technologies, no matter what it is, we'll be able to fund the PSAPs properly.
The WHOSAPs?
PSAPs, Public Safety Answering Points.
Got it. And what does that mean, public safety answering points?
It's just a fancy term for a 911 call center.
Got it. Got it. Okay, thank you. Appreciate that. Next, we have testimony and support from the Department of Accounting and General Services. Next, we have testimony and support from the Public Utilities Commission. Wow, we got the chair. Welcome, sir. Floor is yours.
Chair, Vice Chair, members of the committee, Leo Asuncion, Chair of the Public Utilities Commission, will stand on our written testimony and support, echo everything that Mr. Murakami said. I think technology has advanced, and it's advancing faster than we can keep up with statutes and with regulations. So opening it up to make sure that really for future advancements in technology around 911 services, I think this bill will do it.
Great.
Thank you.
Pleasure to see you, sir. Thank you for being here. Next, we have testimony and support from the Honolulu Police Department. Please proceed.
Good afternoon, Chair, Vice Chair, and committee members. This is Captain Kurihara with the Honolulu Police Department Communications Division. We stand on our written testimony, which is also in support and pretty much echoes the PUC and the E911 board. Basically, it's just a cleanup matter, and where this is really going to help us is essentially when we have to pay our bills and dealing with contracts. When we get too specific, then, if it says this money is encumbered for E911 and now it's called Next Gen 911, that could create problems later. And I'm open to any questions as well.
Thank you very much. Next, we have testimony and support from the Maui Police Department, the Honolulu Fire Department, the Hawaii Police Department, the Hawaii Office of Enterprise Technology Services, and also from the individual Eddie Fujioka and Scott Kidd. Is there anyone else wishing to testify on HB 2339? If not, questions, members? Seeing none, let's move on. Thank you very much. House Bill 2070 HD1 relating to procurement. This measure requires cash or protest bonds to be returned to the initiating parties minus administrative costs as determined by the Office of Administrative Hearings of the Department of Commerce and Consumer Affairs, except in cases where the appeal was frivolous or made in bad faith. First up, we have testimony and support from the General Contractors Association of Hawaii. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Ryan Sakuda on behalf of the GCA. We stand on our written testimony in strong support and happy to answer any questions.
Could you please summarize your testimony, Mr. Sakuda?
Yeah, so previously there was a cap of $10,000 when appealing a bid protest decision. So this is not dealing with bid protests, but this is dealing with the appeals of a bid protest decision that would go to the Office of Administrative Hearings. That cap was removed 3 years ago, that $10,000 cap, and we thought that if that happened, you would then find that you would not have any protests on large projects or appeals of agency decisions on large projects. Typically, with the cap of 10,000, Office of Administrative Hearings was getting 7 to 15 appeals per year out of the sheer number of protests that's actually filed every single year. With the cap removed, we saw that it dwindled down to 3 appeals in the first year, and last year it was actually 0. So we believe that, in deterring frivolous protests, we actually ended up deterring legitimate ones as well. So this is a safeguard language that all the other states use when they use a bond requirement to file an appeal. And so we believe with this safeguard language in that we'd be following what other states have done to not deter legitimate protests as well.
Thank you for that explanation. Appreciate it. Next, we have testimony and support from the Hawaii Operating Engineers. Testimony and support from the Subcontractors Association of Hawaii. Mr. Lyons, please proceed.
Thank you, Mr. Chairman, members of the committee. The Subcontractors Association will stand on our testimony in full support. Thank you.
And you're going to just tell us anything in addition to what we heard from the general contractors?
Well, no, I think the only point is that it really is the job of industry to raise these protests when they come up if government has done something afoul. So we're kind of doing government's work, and I think that should be encouraged to have that police dog out there. And without a return of the money, there's absolutely no reason to protest.
Got it. Okay, thanks for that explanation. And we have testimony and support from numerous organizations: Ralph Inouye Company Limited, Nordic PCL Construction Incorporated, S&M Sakamoto Incorporated, Koga Engineering and Construction Incorporated, John N. Bustard of King and Neil Pacific Inc., and Darren Imada from Moss. Is there anyone else wishing to testify on HB 2070 HD1? If not, questions, members? Nope, no questions. Thank you very much. We'll move on. House Bill 2522 relating to alcohol. This measure expands the definition of beer under the liquor regulatory laws to mean any alcoholic beverage containing no less than 0.5% alcohol by volume obtained by fermentation of any infusion or decoction of malt or any substitute, including alcohol seltzer beverages and excluding sake cooler beverages and other distilled products. It authorizes brew pubs to sell beer they manufacture or beer manufactured on their premises subject to certain conditions. First up, we have testimony and support from Craft Ohana. Testimony and support from Lanikai Brewing Company. Testimony and support from Hanakoa Brewing Company, and testimony and support from Scott Kidd. Is there anyone else wishing to testify on HB 2522? If not, questions, members? Thanks. We'll move on. House Bill 1842 relating to fire prevention. This measure increases the maximum fine for violations of the fire protection laws, specifies that each day a violation exists or continues to exist shall constitute a distinct and separate offense. It raises the criminal penalty for the offense of arson in the 4th degree to a Class C felony if the offense was committed during the time period and within the geographic area in which a red flag warning was in effect. It provides that the state of mind requirement is not applicable to the fact that the red flag warning was in effect, and that the actor is strictly liable with respect to the attendant circumstance that the red flag warning was in effect. For this measure, we have testimony and support from the Department of Land and Natural Resources. Please proceed.
Good afternoon, Chair, Vice Chair, committee members. I'm Rob Hoff with the Division of Forestry and Wildlife under DLNR, and the department strongly supports this bill. As you probably know, most of our fires in Hawaii are caused by humans. And as we point out in our testimony, it's also very important that we increase our capacity for doing fire investigations in order to enforce such a law. And that's something that I think that establishing a fire marshal office would go a long way toward. Something we also wanted to mention that didn't make it into the testimony is that under Chapter 185, the Land Fire Law, there is a penalty for starting fires in division lands that are closed due to fire conditions. However, the penalty there also includes damages associated with the fire and leaving that person on the hook. So that might be something worth considering too, to further dissuade people from starting fires. But I'm available for questions.
So just I'm clear, are you suggesting an additional amendment to this?
I just wanted to bring up that this penalty does exist in Chapter 185. And it might be worth considering. I'm not suggesting an amendment at this point.
Okay, thanks very much.
Yep.
Next, we have testimony and support from the Hawaii State Fire Council. Next, we have testimony and support from the Honolulu Police Department. Please proceed.
Good afternoon, Chair, Vice Chair, and members of the community. I am Thomas Chang, with my captain for the Criminal Investigation Division. HPD stands by, we support this bill. We stand by our written testimony. I'm here to answer any of your questions. Thank you.
Thank you. Next, we have testimony and support from the Maui Fire Department and from the Honolulu Fire Department and from the Maui Chamber of Commerce and from Scott Kidd, an individual. Is there anyone else wishing to testify on HB 1842? If not, questions, members? Seeing none, let's move on to our last measure on this agenda, HB 2311, relating to crime. This clarifies that the secured areas appurtenant to a multi-unit dwelling are included as dwellings for the purposes of prosecuting offenses under Chapter 708 Hawaii Revised Statutes, allows the owner of a multi-unit building or the condominium association to act as a complainant for the purpose of investigating and prosecuting a burglary in the 1st degree in a multi-unit building. For this measure, we have testimony with comments from Tricia Nakamatsu, Attorney General. Welcome. Pleasure to see you. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Deputy Attorney General Tricia Nakamatsu appearing on behalf of the Department of the Attorney General. We are not taking any position on the intent of the bill, just seeking to clarify some of the verbiage that's used that may help to further the purpose, the intended purpose. With regards to the amendment to the definition of dwelling on page 3, line 6, we suggest removing the word exclusive. And with regards to, and we actually did provide suggested language on page 2 of our testimony. I apologize. So those would be our recommended changes. If you have any questions, I am available to answer.
Thank you very much. Appreciate your testimony with suggested amendments. Next, we have testimony and support from the Honolulu Tower Apartment Owners Association. Next, we have testimony and support from the Honolulu Police Department. Please proceed.
Hi, I'm Captain Denise Nakabayashi from Pro City. HPD stands by our written testimony in support. Criminal acts by non-residents within the secured areas of multi-unit dwellings have been a problem. Updating the definition of dwelling to include the secured areas of multi-unit dwellings allows law enforcement investigators to clearly define and identify these crimes as burglaries. Thank you.
Thank you very much. Next, we have testimony in support from James Nelson. Thank you for your patience.
No, thank
Please proceed.
Good afternoon, Chair and Vice Chair, members of the committee. I'm James Nelson in support of this measure. And in my private capacity, because some of you might know me from working in the building, this measure arose from incidents that I actually incurred twice, where the crime was initially reported as a theft, just simply a theft. And once something gets reported as a theft, then that tends to put it in the system forever as a theft. So if it's not treated as a burglary up front, unless somebody like me comes along and says, wait a minute, this is burglary, this isn't theft. They actually broke into a secured area. It was a criminal trespass that, you know, with an intent to commit a crime, and that's a burglary, much less a burglary of a dwelling, which is the case of a multi-unit building. So it's really not, it is possible to charge these crimes as burglaries, but if they don't get off the ground as burglaries, then they will not be investigated as burglaries and they will not be prosecuted as burglaries. So I was hoping that this, we're not increasing something to a felony here, we're just kind of clarifying that in the case of these multi-unit buildings, that, that burglary can be investigated from the first instance. And then I would make the point that the Homeowners Association, what happens is that it's the Homeowners Association that keeps the surveillance footage and often has control over what staff members look at different aspects of the building. And so they're actually in a better position to follow through with the police and with the prosecutors for crimes of this type. And I have looked at the AG's testimony, and I think their amendments are fine as well. I also suggested some other language that might be used. One of the things that came up when I was talking with HPD is to what extent is this area exclusive from the public? So that's why the word exclusive was in there from the beginning, because if it's a shared public parking, then certain types of configurations of certain buildings might require certain types of signage or security apparatus. So it does depend to a certain degree on the building, but I think the AG's language is fine too, and if you have any questions, I'd be happy to answer them.
Just could you explain your amendment that you have in your testimony?
Well, I have had a conversation with Attorney General Nakamatsu, and they were kind of concerned about what secured might mean or not mean. I think one could leave that to, you know, the circumstances in a jury and what might happen in a trial. But if we were trying to avoid the word secured per se or listing certain types of security apparatus, we might take the other approach, which is to say, because the AG's was not comfortable with the word exclusive, that we might say something to the extent that it was a restricted area that was clearly marked or either by its apparatus or its signage as restricted to residents only, so that once potential burglars were on notice that the area was restricted, then at that point they knew they were entering a dwelling. Okay. So you can approach it from different angles with different language. So
okay,
that's what the
Thanks
situation is.
Thanks for that explanation. Appreciate
Thank you
it very
much.
Next, we have testimony and support from Greg Misakian, testimony and support from Lynn Matasau, and testimony and support from Scott Kidd. Is there anyone else wishing to testify on 2311? If not, questions, members? Ms. Nakamatsu, if I could ask a question. Mr. Nelson had suggested some additional language, you know, to say that this is an area access to which is clearly restricted to residents by means of signage or security apparatus or both. Is that necessary?
We do feel that additional definition is needed for the term secured, but we can go ahead and review any proposed language, that language, and go back and forth and try to work on something, if the chair would like.
So you just don't want to tell me what your thoughts are right now? To the language that was suggested? I'm just curious, because it'd be nice to move this along.
I think a lot of it is policy-based, is basically what you want it to apply to. Some of the examples that we listed in our testimony, something as simple as a single chain going around the perimeter of a parking lot, that's pertinent to a multi-unit building, also used as a dwelling. Is that going to be included? Just to make sure that the definition includes the types of areas that you want to. Or if something's, say, not chained off at all, it's maybe not fenced, but it's covered by a security camera or signage. I think it's more a matter of policy and then crafting the definition to fit.
Because your suggestion is dwelling means a building adding, including a multi-unit building, which is usually used by a person or persons for lodging, and shall include any clearly marked and secured appurtenant parking or storage area.
Correct. On top of that, we had suggested a definition for secured, but because we're not exactly sure what types of areas the committee or the introducers would like to include, we didn't try to guess at what that definition might look like.
Okay, and then you suggested the other amendment, in the case of a dwelling that is a multi-unit building, an owner of an individual unit or of a building, a property manager or an authorized representative of the condominium association may act as a complainant.
Correct, and that's just to clarify in terms of multi-unit buildings, condominium associations, that who would be able to act on those offenses, or who would be able to represent the complaint or be the complainant.
Okay. All right, well, thank you for those suggestions. Appreciate it.
Thank you.
Okay, any other questions, members? If not, thank you very much. Let's move on to decision-making, back to the top of the agenda. Thank you to all the testifiers for being here today. First up, we have House Bill 1918, HD1. For this measure, I would like, it's already got a defective effective date. I think it's a good measure. I would like to include, I'd like to recommend we pass it out as is, but include in the committee report the caps for total tax credit for future tax years as listed in the original bill. It would be $1.5 million for the 2025 taxable year, $2 million for the 2026 taxable year, $2.5 million for the 2027 taxable year, $3 million for the 2028 taxable year, $3.5 million for the 2029 taxable year, and $4 million for the 2030 taxable year. We'll put that into the committee report. That's my recommendation, passing it out as is with those things in the committee report. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1918 HD1, passing as is. Chair and Vice Chair vote aye. Representative Evslin, excused. Representative Ganadin. Aye. Representative Holt, excused. Representative Ichiyama. Representative Ilagan. Aye. Representative Kong. Aye. Representative Miyake. Aye. Representative Souza, excused. Chair, your recommendation is adopted.
Thank you. House Bill 1902 HD1. I'd like to move this out as is. No changes. Any questions or concerns, members? If not, Vice Chair for the vote.
I'm sorry, was
This as is, yeah.
sorry.
HB 1902 HD1 as is.
Voting on House Bill 1902 HD1, passing as is, noting the excused absence of Representatives Evslin, Holt, and Souza. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. On the next measure, House Bill 2611 HD1, I recommend passing out with amendments and include the recommended amendments from the Department of Land and Natural Resources, Bureau of Conveyances. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2611 HD1 with further amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. House Bill 2473, HD1, I recommend passing out with amendments. We need to make some technical amendments, but I'd also like to include the recommended amendments from the Department of Land and Natural Resources. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2473, HD2, any reservations or noes? Your recommendation is adopted.
Thank you. Next measure, House Bill 2174, HD1. I recommend we pass it out with amendments. We need to make some technical amendments. I want to include that the report under subsection C should also include information on the persons that were searched for. It already has a defective date, so that would be the amendment. Technical amendments and that one amendment I just mentioned. So it would be an HD2. Any questions or concerns, members? Representative Ganadin.
Thank you, Chair. I'm going to be voting no on this. I think that the small amount of money that the government might be able to get reimbursed for is not outweighed by the safety issues that have been brought up. Similar bills come before the legislature every year, and I'm just concerned that it's going to have a chilling effect on people asking for services to save their lives.
Understood. I appreciate that concern. I do note that this is for people who are trespassing. They're going on closed trails or areas that are clearly signed as being off limits. But I appreciate that that's a concern. And I also want to note that this is now the second year that a state agency, Department of Law Enforcement, has testified in support of this sort of thing. So it's a conversation. I appreciate there's concern, and it's a valid point, Representative Ganadin. I appreciate you bringing it up. Any other comments or concerns? If not, Vice Chair for the vote.
Voting on House Bill 2174, HD2, noting the no vote of Representative Ganadin. Any other noes or reservations? Reservations for Representative Kong. Chair, your recommendation is adopted.
Thank you. Next measure, House Bill 2420, relating to the Department of Hawaiian Homelands. I recommend we move out of House Draft 1, defect the effective date to year 3000. And I just want to commend Department of Hawaiian Homelands for moving forward with their work on implementing Act 279, and just to make sure that they don't lose the opportunity to use all of the funds that we appropriated. This measure is important, so I ask for the support of the members. Pass out this bill with amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2420 with amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. House Bill 1932, House Draft 1. I recommend we move this out with amendments. We need to make some technical amendments to this. That's all I'm recommending. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1932, HD2. Any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. House Bill 2673, HD1. On this measure, I would like to recommend we move it out with amendments, and I would like to adopt the amendments from the Attorney General in their testimony. It already has a defective date, so that would be my only recommendation, is incorporate the AG's recommended amendments. Questions or concerns, members? Representative Ganadin.
With respect to the introducer and in appreciation of the danger that speeding causes on our roadways, I'm going to be voting no. I can't think of anything that would take over the news cycle or irritate.
This is 2673.
Oh! I was about to talk about speeding.
No, we're not there yet. You're speeding.
All right. Well, then I'm good on this one.
Busted.
Yeah.
You're speeding.
All
Slow
right,
down.
Well, I did appreciate the introducer, didn't I?
Slow down. 2673, recommended moving out with just the AG amendments to an HD2. Questions or concerns, members? You're okay. All right.
Voting on House Bill 2673, HD2. Any reservations or noes? Your recommendation is adopted.
Thank you. Now, catching up to our good Representative Ganadin, we're at House Bill 2267, HD1. I think that there's a number of problems with and issues that people expressed in questioning on this measure. And so I think it's not quite ready to move out of this committee, so I'm recommending that we defer it. Questions or concerns, members? Took the wind out of your sails. Sorry about that, Rep. Okay, moving on. House Bill 1934, HD1. I think that the Department of Transportation is already addressing this through their strategic highway safety plan, but deference to the chair of the Transportation Committee, let's move this along with amendments. Include the Department of Transportation amendments, include the Department of Law Enforcement amendments, make some technical amendments, and I'll note that the DOT is chairing this and they could add members to this as they see fit. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1934, HD2. Any reservations or noes? Your recommendation is adopted.
Thank you. House Bill 2339. This is good to catch up and get us out of the dark ages. Instead of calling it enhanced 911, we can move forward to so that make this change within this bill so that the 911 service can adopt new technology, and I think that's a good thing. Thank you for members being here to advocate for this, the testifiers. So on this one, I think we need to move it forward. On 2339, we do have to make some technical amendments. I also want to make sure that references to enhanced 911 under section 269-1 and 269-16.95 also be amended so that we're consistent. And defect the effective date to the year 3000, just to make sure we got it right. We'll have a chance to revisit this. So this would be HD1, technical amendments, the amendment I just mentioned, and then defect the effective date to year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2339 with amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. Next one, House Bill 2070 relating to procurement. It's already got a defective date. It's a good idea. Let's move this out as is. Questions or concerns, members? Vice Chair for the vote.
Voting on House Bill 2070 HD1. Any reservations or passing as amended? Passing unamended. Any reservations or noes? Your recommendation is adopted.
Thank you. Next measure, House Bill 2522 relating to alcohol. I'd like to pass out with amendments and defect the effective date to the year 3000. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2522 with amendments. Any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. House Bill 1842. On this measure, I'd like to recommend we move it out with amendments. We have to make some technical amendments needed for clarity, consistency, and style. And I'd like to defect the effective date to the year 3000. Questions or concerns, members? Vice Chair for the vote.
Voting on House Bill 1842 with amendments. Any reservations? Reservations for Representative Ganadin. Any other reservations or noes? Seeing none, your recommendation is adopted.
Thank you. Finally, House Bill 2311 relating to crime. I recommend we move this out with amendments. I'd like to adopt the AG's amendments, defect the effective date to the year 3000, and if we need any clarification, we will be contacting you at the Deputy Attorney General just to make sure we understand your recommendations. And I'd like to go with that now, and if the Senate thinks they want to modify it further, then we'll consider that. It'll come back to us because we're going to defect the effective date to 3000. Those are my recommendations. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2311 with amendments. Any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. There being no further business before this committee, we are adjourned.